He testified, Your Honor, that he did send this email. He was looking for help in his campaign from Mr. Preston. This is the one he testified. Mr. Preston called him back about and was kind of upset that he sent this on his phone.
That's right.
Yes, sir.
I heard.
And then what happened, though, Your Honor, was we asked Mr. Thompson, did Mr. Preston help you raise money for your campaign in 2008? And Mr. Thompson says he did.
He acknowledged that.
Right, and not that he did it on company time or anything, but that he did. And Mr. Preston denied that he didn't. So that's
Except, there's, and let me just put in the except part. The part that was left out was, we also saw the video clip where
Mr. Preston hasn't testified yet, Mr. Tessier, so
yes, sir.
I can't really consider that at this point in time. Go ahead.
That Mr. Tessier also asked Mr. Thompson about donors, and they were going through these big long lists of donors, and you only saw the excerpt, but before that, there was a big long list of the which was, oh, you don't, and you don't think that. And they got to the very bottom of it. They said, look, can you tell me for certain whether any of those people were actually people that Mr. Preston helped you contact? And he's like, no. Well, did you know all of them? Yeah. I think you may remember those passages where he said, no, I knew all. At that point, I had been on the council for 3 years, and I knew them. And the whole point of it is that it's a struggle to see how it relates to a contract dispute about the severance agreement.
All right. Well, it was testified to, and that's in the record, and I'm going to, that I don't see that it contradicts the testimony that's given, so I'm going to allow it.
No, I'll just say point of order.
Yes.
I think the next step, Your Honor, would be to discuss excerpts that we would like to play from Mr. Preston's deposition. Our proposal, as it has been all along, would be to play both sides' designations at the same time, just to be more efficient with it. Our suggestion, Your Honor, for our objections to their designations is simply to basically do what we did with Mr. Thompson. In other words, include them in the tape. I would like to hand you just our noted objection areas so you would have them, and then you can take them for what they are worth.
All right.
They may want to handle theirs in a different way, but that's certainly fine. I'm including as well, Your Honor, their response to our objections so you would have them.
Okay, so Troy, you've got our responses there. Okay, great. And then, Your Honor, we have objections to some of their designations. One of them includes an exhibit that I do think needs to be taken up. Troy, as I did review, I'll withdraw the objections on page 194 and 238. So I'll withdraw those, but the other ones, I think we need to address.
All right. Do you have yours in writing? Is this back?
I do, and I don't know where I have them at this point.
So you can sign.
You can use this one. I'll stand next to you.
Okay.
These are yours, right?
Yeah.
Yours is 7 years.
Yeah, I was wondering.
I have a number of messages for all of them.
Doesn't have the my objections.
I don't explain why.
Okay, that's fine.
Sure, thoughts too. No, if I may.
One moment, let me take a look at this. Can you help me with your color coding?
Yeah, we started with yellow highlighting, which sometimes looks more green than yellow, but the yellow was primarily our designations, plaintiff's designations. The green was primarily defendant's designations. If there's any pink, which I'm not sure there is, that would have just been counter designations. But typically, we try to keep yellow for the plaintiff and green for the defendant. And then what we also did, Your Honor, is you'll see some handwritten notes where there are sections that have had an objection raised, because that might draw your attention to it a little better.
The first document you handed me was your responses to plaintiff, defendant Preston's responses, plaintiff's objection to defendant Preston's counter.
Yes, Your Honor.
I'm trying to get through all this.
It's hard.
I'm confused.
Yeah.
If you look on page 2, Your Honor, what you're going to see is in the middle of the page in bold, that's our objection. So if you look at the Defendant Preston's counter designations and objections regarding deposition Joey Preston,
Oh, that one is moving to get me.
I think that's the old one, Your Honor, I apologize.
That's your counter to hours, probably.
Yes,
Is this yours?
those ones are test years. Troy, can I share this with them? This one?
Yeah, well, a few notes of mine on it, which
Just
is,
on. Your Honor, if we just, let me just go through them and if you can look at the deposition, that might be easier. On page 154, lines 6 through 156.
Just give me a minute to get the 154, you said?
Yes, sir. Starting on page 154, line 6, going through page 156, line 6. There was a discussion going on and question and answer regarding a South Carolina Retirement Systems email that was between 2 South Carolina Retirement Systems employees. And the plaintiff wants to not only admit the testimony that's going on, asking Mr. Preston about this email, which Mr. Preston had no personal knowledge of. This is between 2 South Carolina Retirement Systems employees, and it's hearsay within hearsay. It's one employee telling another employee what a third employee said when they talked to Mr. Preston. And so we would object to that whole line of questioning there because it's hearsay within hearsay. We also believe that
So
exhibit.
you're talking about 154, starting at line 6.
Yes, sir.
Going through 156 and line 5.
Line 6,
Six,
where
I'm
the
sorry.
answer is. And so that whole conversation and the exhibit itself, their designations not only want the designations in, but they want us to put the exhibit in with it. And there's no foundation for the exhibit. The exhibit is hearsay within hearsay. Mr. Preston can't authenticate that email. Mr. Preston can authenticate what 2 other employees at SCRS are talking about that a third
Let's see
employee.
what they say about that.
Your Honor, first of all, the exhibit itself is not within our trial exhibits. And as you can see from that exchange, I made it clear to Mr. Preston that I knew he had not seen this letter. I was trying to give him a frame of mind of what time frame were you inquiring of the retirement system. And so I just asked him, I'm not suggesting you've ever seen this on line 20. The reason I'm showing it to you is just to see if this helps you remember when you might have been inquiring about the purchase of service credit. And then through that exchange, he ultimately agreed, yes, it was early July morning. So that's all we were using it for, was to get him in the right time frame.
Well, he ended up in the right time.
That's right.
So
Took
the
a while.
contents of the emails and those significant,
That's right.
I'll sustain the objection.
The next one is 188, Your Honor. This is in regard to the buyer 1 and 2 posting positions. And what Mr.
Let me get there before we start.
Sure. I'm sorry, Your Honor. It's
188, you said?
188 beginning at line 12.
All right, yes, ma'am, I'm there.
And it includes page 188, lines 12 through 25, and 191, lines 1 through 5, and lines 19 to 21.
Yes, ma'am, I see where you are.
It also includes the second pages of exhibits 29 and 30, which have affirmative action information. And Mr. Preston testified that as county administrator, he never would have seen this affirmative action report, that it was something that stated personnel. He couldn't identify it, that it had nothing to do, that he had nothing to do with individual job postings, that that was all handled by personnel. Additionally, Your Honor, so there's a foundation issue on that, the second page of those exhibits, but the other issue is the best evidence rule. Your Honor, Mr. Preston testified and asked repeatedly in the deposition about the personnel action form. And the personnel action form is the best evidence of when an employee was actually hired. That's what Mr. Preston signed off on as the county administrator. And to date, the county has never produced the personnel action form that Mr. Preston signed regarding Michael Thompson having a job with the county. And Mr. Preston asked about it in his deposition. Mr. Thompson mentioned it in his deposition, as you just heard. And to date, we've never seen that. It's the best evidence of what position Mr. Thompson was actually placed into by Mr. Preston and when he was placed in that position, or when he was hired for the position that would have been starting on January 2nd. So we would object based on a foundation issue and best evidence rule.
Yes,
It has nothing to do with the best evidence rule. These two exhibits, 41 and 42, the job advertisements for the buyer one and two positions, were pre-admitted into evidence. Mr. Thompson has also testified about them, so they're in evidence already. And Mr. Preston did agree, and I'll admit, Your Honor, Mr. Preston said he was not familiar with the affirmative action report as the second page, but he said he had seen job advertisements like this in the past, so he knew what they were. So I don't see the point of the objection in that. It's already in evidence.
but is the document already in it?
I believe it was pre-admitted, but at the time we made the objections.
I understand. I'll overrule the objection.
The objection on page 194 is resolved. On 197, lines 4 through 6.
Yes, ma'am, I'm there.
And the question was, and the day you didn't reverse your decision was November 18th. Mr. Davis objected at the time, saying that that was a double negative question and an unclear question. And you would also continue to assert it was an unclear question in lines 4 through 6 in a double negative.
Well, yes, Your Honor, I've never heard of an objection double negative before.
Well, I don't know if that's objectionable in and of itself.
And it may prove true that I was my own worst enemy, because if the Honor doesn't understand that the testimony...
It's a rather confusing question, I'll admit that.
The point of it, Your Honor, was he had to make an affirmative choice at some point in time to hire Mr. Thompson. He made that affirmative choice after November 18, 2008, when Mr. Thompson had voted in favor of a $1.1 million severance agreement. Mr. Preston didn't like the way I was phrasing that, because he said, oh, I didn't make an affirmative choice at that point in time. I had already made the decision long before, and I did not reverse my decision. So then I had to pitch it as a negative. Okay, so you chose not to reverse your decision after November 18, 2008. That's what happened. He had to do something affirmatively, which turns out to be he supposedly signed a personal action form and hired Mr. Thompson, but not until after the vote had occurred.
Overruled, I'll leave it. I think I understand what it's about.
And then on page 197, starting at line 20 through 198 through line 3.
I'm sorry, say the page number again.
Same page, Your Honor, starting at line 20 on 197.
I'm there, I see.
Going through 198 at line 3. There were several questions about whether the buyer two job got defunded. And Mr. Preston said he didn't know it, and that it calls for speculation, and assumes facts that are not in evidence at that time. To this day, again, whether the buyer two job got defunded is an issue that they have the personnel action form that they've never produced to us. They have the financial records. They could put up a financial person from the county to testify about whether that got defunded, but Mr. Preston testified he didn't know. And so there's no foundation for him knowing. And it calls for speculation on his part.
Your Honor, we were just struck, and I think Mr. Preston was struck by the irony of the situation that Mr. Thompson voted the night before on defunding.
He says he didn't know it, but his other answer was that's entirely possible, but unlikely, but he still didn't give a definite answer either way. I don't know if it is an answer to the question, so I'm going to leave it in. I mean, I don't think he really said one way or the other, whether it occurred or didn't occur. Like you say, if they can prove it, they can prove it.
Thank you, Your Honor.
So I'm going to leave it in.
On question 227, or I'm sorry, page 227, lines 6 through 25.
Give me a second to get there, please.
I have it highlighted on mine.
Oh,
6 through 25. I was objecting, it's not highlighted. Are you okay with that amendment?
229.
227.6, that one there, starts with 227.6.
I don't have that, it's not marked on there. I have it on page 229.
Yeah,
Yes,
that's
so
the
it's
next
not,
one.
it's one before that one as well. 226.20 to.
I see an
20 to
objection
5.
on 229.
Yes,
Is
sir.
that what we're going to?
No,
Well, there was one in between.
that one,
Okay, that one's been taken out.
It's not marked on there.
Page 229,
Yes, ma'am.
lines 6 through 11.
Yes, ma'am, I'm there.
And our objection on that is that it assumes facts not in evidence in front of Mr. Preston at the time he testified. The recusals themselves are the best evidence of the reasons for recusal. And I believe Mr. McAfee's already testified about the recusals and the recusals being into evidence yesterday. So I think that one is cumulative. Mr. Preston testified he didn't know on what matters Mr. McAfee recused himself about.
Our point on that, Your Honor, was simply the knowledge of Mr. Preston, and the knowledge was, and he does remember this, he remembers that there were occasions when Mr. McAfee recused himself because he indicated he was a business associate from East Plum. That's the point. So then later on, when Mr. McAfee votes in his favor, that's just something worth consideration, we believe. So we think it's certainly admissible.
I'll overrule the objection. I'll leave it in.
Okay. With regard to page 236, starting at line 220, or line 22, going through 237 and line 8. Again, there's a foundation. Mr. Preston said he had no knowledge of which rail trends conferences Mr. McAfee attended, that there was a document he was being shown that he couldn't authenticate because his signature was not on it. I believe that since then, the rail trends documents came in through Mr. McAfee's testimony. So again, Mr. Preston, there's a foundation issue, there's an authentication issue on Mr. Preston, and it's cumulative.
Yes, sir, Mr. Besser.
That one has been pre-admitted, Your Honor. I believe the Rail Trends Conference document. I think his answer stands for what it is. He says he knows he went to some Rail Trends conferences, wasn't sure about that particular one, but leading up to that question, he does agree, and this was the question that was most important to us, do you agree in general terms that Mr. McAfee traveled frequently with the plumber? Yes, sir.
Or so you're saying you don't care whether this gets in or not?
I care about the first portion, Your Honor, but I don't think the other one really has any value to you. So whether you take it out or not, won't have much impact, I suspect.
And again, from a cumulative standpoint, Your Honor, Mr. McAfee has already testified to all of that.
Well, I understand that, but it's not cumulative in that you're offering, you can offer evidence to show that other people do those things.
Yes.
I'm gonna leave it in.
And 243 lines 1 through 7. And I'll just read that. That's not true. On lines 1 through 7, they were talking about a CSX rail line happened 9 months before their travel, and it assumed facts that are not in evidence, that to my knowledge are still not in evidence, and the relevance of that to the issues at hand.
Yes, Mr. Besser.
Your Honor, this was a question we asked Mr. Preston about whether or not any of the trips that Mr. McAfee took with Ms. Plummer resulted in any affirmative economic benefit to the county. And he had a lengthy explanation over the course of several of the prior pages, which are not objected to. And this is just the finishing part of that question where we asked him, because he was explaining, he said, Your Honor, well, there was this CSX rail line that was not discontinued or something. So he was trying to attribute that to what Mr. McAfee had done. And then I asked him, when was the CSX rail line not discontinued? He said it was the prior year, before the trip had occurred. And so the final question that they're objecting to was, won't you agree with me, Mr. Preston, that October 2008 travel had zero to do with the CSX rail line that you talked about that happened some 9 months before? And he wouldn't agree with that.
Your Honor, I think the evidence that came in under Mr. McAfee yesterday was that the travel had been going on since 2006. He had gone to several rail trans conferences in a row. And so, I think that that particular part of the answer, that's the only one that's being objected to. We didn't object to the rest of the stuff.
I'm going to overrule the objection. I'll leave it in.
With regard to page 245, lines 14 to 19. And again, they're saying, they're asking about the trips, and Mr. President says, I don't have any personal knowledge of that.
Well, the objection there was to the form of the question. I'm not sure what was objectionable about the form. So is the answer, you don't have any evidence that these two particular trips brought back any benefit to the county in objection to the form?
Well, I think the objection to the form is that that was the answer. The question asked before that, which is already in evidence, or has already been designated, is Mr. Tessier said, he told us he got no fish, they brought no benefit back. That's what he told us. I'm asking what evidence do you have that Mr. McAfee brought back some benefit to Anderson County as a result of these trips we talked about in October 2008. And his answer was the economic development officials in Anderson County, including myself, would often go on trips in order to try to bring a fish to the community. And you didn't always land one. I think the important thing was you continued to fish.
Well, that's been testified to. Is this a typo here? It shows two answers
It's a
instead
typo.
of a question, so that shouldn't be a question.
Right.
Okay.
The first one is the question, Your Honor, at line 4.
Yeah.
So
All right.
it's just the piece from 14 to 19 that it was already asked and answered, but the next question of it's confusing, and then there's is the answer. He says, well, I don't have any personal knowledge.
And that's the whole point of the question, Your Honor, what we were establishing that he had no personal knowledge of any evidence that those particular trips in October
Yeah,
08.
his testimony was that when you take a trip, another testimony too, those trips build relationships. It may not, any particular trip may not do anything, but a series of trips may do something.
Absolutely.
And that's been testified to now.
And we didn't object to that portion of the question before. We're just saying we should get to ask the final question, which was, are you aware of any actual hard evidence?
I'll overrule the objection.
The next objection, Your Honor, goes page 252, and the argument is relevance. This goes to the Germany trip that Heather Simmons-Jones, they allege that Mr. Preston authorized Ms. Simmons-Jones to go on a trip when he was transitioning as the county administrator with Michael Cunningham on December 1st. They've already put Ms. Simmons-Jones' testimony into evidence. Ms. Simmons-Jones never went on the Germany trip. And so it's our position that it's irrelevant because anything that they assert would have been wrongdoing about it, if it was wrongdoing, didn't come to fruition.
You say it never got done.
That's correct, Your Honor.
What would be wrong with it? Let me hear this question.
Our point, Your Honor, is not whether the trip ever actually happened. I think we conceded it never did. But the point of it was you have a gentleman who's not the county administrator saying it's okay for you to take this trip, which he had no authority to give. That's the point. So whether that the answer turning out that the trip never happened, maybe that goes to the weight of the indiscretion on his part, or it still comes in.
Can't be overruled. I'll leave it in for what it's worth.
Your Honor, the next portion is from page 269 to 276. And this is the big issue. Your Honor, this is about a caterer's license that happened in 2006. And Your Honor,
Before
wasn't,
we enter into that discussion, I'm going to take a break. There's some things I want